procedure. Therefore, it is erroneous, therefore, to suggest that the Act does not guide the exercise of the power to punish for the contempt of court, while Article 129 and 215 may be the source of power. It does not mean that the Act can be ignored or brushed aside. This aspect is clear from a reading of Section 9 of the Act, Section 3 to 8, and Section 13. Um, Section 13 is recently amended, explicitly provided that subject to the conditions, mere criticism of the working and functioning of the court or a judge or his judgment will not amount to contempt further. The word contempt is not defined in the Act, but the phrase contempt of court is and that enables us to appreciate that the right to free speech and expression and the freedom in that behalf is neither taken away, curtailed, or interfered with by the Act. The law is designed to uphold the majesty of law and dignity of the court to secure a feeling. Sir, please go now.
Yeah. Okay.
Yes, sir. Of the confidence of the people in general and for a due and proper administration of justice in the country. The Act does not suppress truth. Section 13b provide for justification in the public interest and a bona fide request for invoking a truth as a defense. In my humble view, in my humble view, the request for doing away with the act is not justified at all. Such a law can exist along with the Constitution of India, particularly when the substantive power to punish for the contempt is derived from the Constitution itself.
Right. Okay. Good. Now, what did you understand from this passage? Tell me.
So this passage talks about, first of all, talks about say Article 129 and 215 of the Constitution, which confers the court of record that the court have to make a record, and then it talk about the contempt of courts.
Right. It talks about contempt of court. Now, basically, contempt of court, the provisions for contempt of court are found in two places. First of all, it is found in the Constitution itself. Okay. Constitution itself contains two separate articles for contempt of court. One is regarding contempt of Supreme Court. One is contempt of High Court, isn't it? And then you have got a separate contempt of court act. Right. Now, what it is saying, this article, is that is there really a need for a separate contempt of court act when you already have the Constitution of India, which contains the contempt provisions, right? What is the need for a separate act? Now, what do you think? Is there a need or not? Well, logically speaking, if the parliament has enacted a law which is separate from something which is already there, obviously they are also not fools sitting over there. Well, that is a debatable issue. But obviously, there must have been some logic behind passing a particular law, okay, which is actually found inside that law also. If you read, if you ever open any act and you see over there, they have given the recital. Okay, recital means the purpose of this act. An act to define the laws of contempt and the powers of the court to, hold someone in contempt of itself, etc., etc. Okay, like that kind of thing. Now, what is the need for a separate contempt of court act when it is already there in the Constitution of India? Because there is some procedural guidelines which are laid down in the contempt of court act which don't exist in the Constitution. Okay, what you must do when you face such passages, not inside, don't wait to enter into the exam hall, but right now when you are practicing, okay, whenever you read something like article 129 of Constitution, you must immediately go and see what is Article 129 of Constitution. Okay, so quickly tell me what is Article 129 of Constitution. Come on, what does it say? Quickly tell me.
I think so. It says that the court can bring on record anyone
No,
who.
I mean to say that Google it and read it out and tell me what does it say.
The
Like
art,
you should know the exact provision which is mentioned over there in that law. That's the only way you will really learn, isn't it? So tell me.
the Article 129 of the Constitution of India 1970, which makes the Supreme Court a court of record and confers the power to punish for contempt of itself.
But that is not what the article itself is saying. That is something which is describing. I'm telling you, Google Constitution of India, Article 129 itself.
So, Article
Understood?
129, Supreme Court to be the court of records. The Supreme Court shall be a court of record and shall have all the powers of such a court, including the power to punish for contempt of itself.
Very good. Right. Now, what does this mean? What is contempt? What is court of record? Nothing is written over there. It's simply written that the Supreme Court has the power to punish for contempt of itself. How, why, what, where, who, nothing is mentioned. So the contempt power is found within the Constitution, but the procedure, the way, the manner, the rules, nothing is written there. That you will find in the Contempt of Court Act. That is why you need a separate act over and above the Constitution. You understand now? This is basically what this passage is trying to say. Okay, what is the need for a separate act when the Constitution is already there? Now, do you understand what is the need? Can someone tell me what is the need for a separate act? Whatever I have just explained, after
So
understanding that,
as you said, sir, to provide a proper procedure of how a contempt of court case can be brought in by the court and how the procedure should be carried out. That is all
yes,
given in the Contempt of Court Act.
absolutely. While Articles 1, see in the passage is written that while Articles 129 and 215 be the source of power, it does not mean that the act can be ignored or brushed aside. This aspect is clear from reading Section 9 of the Act. Okay, what is Section 9 of the Act? Quickly tell me. Now, what you have to do? You have to Google Contempt of Court Act, Section 9, and you have to tell me what it says. Okay, you understand? The more proactive you are, the better it will be for you in the exam hall. Okay. So when you see something like Contempt of Court Act, Google that act. Read little bit what is written inside that act. Don't read a commentary on it. Don't read a news article on it. Don't read a review of that. Read the act itself. Right. Directly go to the source and read that. Don't bother about reading some comment. This is why I tell you, even for GK and all, don't read compendiums, daily compendium, weekly compendium, monthly compendium. Why? Just read the newspaper. Go directly to the source of the matter rather than trying to find some kind of like, ready-made, ready-to-eat kind of a thing for yourself. Eat the natural thing. It's better for you, isn't it? This is what we always say, right? Eating the natural thing is better. Don't eat processed things. Same goes for GK. Same goes for every other subject in class. Okay. And most importantly, it is for legal reasoning. So when you see any section over there, read that section in its entirety, in its original form. Okay. So now, what is section 9? Anyone has found it yet?
Yes.
Yeah. Read it out. Go on. Come on. What happened? Still not found. You all need to be quicker than this. You won't get so much
Uh,
time.
so, Section 9 of Contempt of Courts Act not to imply enlargement or scope of content. Nothing contained in this act shall be construed as implying that any disobedience, breach, publication, or other act is punishable as contempt of court, which would not be so punished apart from this act. Nothing contained in this act shall be construed as implying that any disobedience, breach, publication, or other act is punishable as contempt of court, which would not be so punished apart from this act.
Can you read it again? I think your voice is not very clear.
Uh, yes, am I audible? Is it clear now?
Yeah, yeah, yeah.
Uh, Section 9 in the Contempt of Courts Act not to imply enlargement of scope of content. Nothing contained in this act shall be construed as implying that any disobedience, breach, publication, or other act is punishable as contempt of court, which would not be so punished apart from this act.
Right. So don't you think this is kind of giving the limit and power of certain courts in punishing contempt to and giving regulating the procedure for it? Basically, it's saying that, right? Nothing in this act will restrict this thing and that kind of thing, right? So of course it is very necessary as compared to the Constitution of India alone. Okay. So basically, when you read the section, things become much more clear. Okay. So after the class, when you are reviewing this class, you must look at section 3, 8, 13, as well as article 129 and 215, right? The same way you have read section 9. Okay. Good. So now let us move to the questions. All right. First question. Now I will call upon anybody. Okay. So all of you have to be ready. And first question is for Varishtha. Varishtha, tell me, which of these arguments is not made by the author?
So, can you give me 1 minute?
Yeah.
So, I think it will be option D. The law of contempt secures and upholds the proper and due administration of justice in India.
Okay. And why do you think so?
So, because I
Like,
think
I'm
I
not
read
saying
it
that you are
somewhere
right
above.
or wrong. Yeah, I'm not saying you are right or wrong. I'm saying, like, why do you think so?
Yeah, because sir, in the passage, it said na about, oh, it was given there above.
Okay. Anyone else? What do you think? She's right or she's wrong, Varishta? Yes, Shantanu, what do you think?
So answer option C is correct, since the question is asking which of these arguments is not made.
Which of these arguments is?
Not made. So, like
Mm,
going by that, answer option C is correct. The law of contempt ensures that the feeling of confidence of the people in the courts is secure.
okay. I think that is also, you're saying option C, isn't it? I think that is also given, that the contempt, that the feeling of confidence in the people is secured. See, here, can you see that? The law is designed here, this part. You see, this part.
Yes, okay.
Actually, the answer is A. Okay. It is clear from the excerpt that the author does not claim that the law of contempt protects the individual reputation of judges. It upholds the dignity of the court as a whole. Okay, so when the passage is talking about dignity, it's not talking about dignity of a particular judge. Okay, if you're insulting a particular person, that's not the reason that the law exists. The law exists to uphold the institution, because you're not insulting that person as a human being. You're insulting that person as representing that institution. Okay, and that is wrong. Like when we had the coronavirus pandemic, at that point of time, some of the doctors were being attacked, right? And there was a law which was, or ordinance that was passed, punishing those people who were attacking doctors. So was it because of that individual person who was being attacked that this law was made? No, it was because the medical profession as a whole was being attacked, and to protect against that, this ordinance was made. Similarly, when it comes to judiciary as an institution, you have the law of contempt. Okay, so that's why the answer will be A. But both of you have given good answer, and that's good. Okay. Now, second question. Very simple question. John, what is the answer?
So I think the answer is option C, both A and B.
Obviously, that is very clearly written in the passage and also in the Constitution of India, if you see. Okay, fine. Question 3, Ashank.
So I think option C.
You think option C.
Yes, sir.
Why do you think option C?
But because it is mentioned in the paragraph also.
It is mentioned in the paragraph also that truth can be a defense in its public interest and invoked through a bona fide request.
Yes.
Okay, very, very clearly written over here. Okay,
Here.
here.
Yes, sir.
Okay, okay. Clear to everybody? I hope it's nothing confusing in this one. Fine. Let us move to fourth question. Um, Mimansha,
Yes, so
what is the answer to question number
so
four?
I think option B is correct.
Why?
Just a minute. Because it's mentioned in the passage that it's for the parliament to if the law won't like if the law is to be repealed, it completely depends on the parliament and the legislatures. So
Okay, okay. And where does it say so in the passage? Can you tell me the uh, paragraph number or the line where it says this?
yes, sir, just a minute. Sir, I read it somewhere now. I'm not able to find it out.
Here it is. You see?
Okay, yeah, it is for the parliament and various state legislatures.
Right?
Yes, sir.
Clear enough? Okay,
Yes, sir.
good. Fine. Okay. So let's move to question number five now. What is the central argument in this excerpt? Priyanshu.
Option C, sir.
Why?
Because in the whole passage, the author is against repealing the contempt of court law, and also in the last passage it says that the law itself derives its powers from the constitution. So I think so the option C would be the most suitable one.
Very good. Okay. So you all have done this passage very, very quickly and very, very correctly also. Okay. So this is how I want you all to proceed with the other passages also. Okay. Great. Good. Now let's move to the next question, next passage. Okay. Second passage. Um, yes, Mimansha, go ahead. Please read it out.
The passage says the Supreme Court's eviction order ignores the rights of Juggi dwellers, Rishika Sangal, Indian constitutional law and philosophy. In 1985, a five-judge
Okay.
bench
Juggi
of
dwellers
the
are what? Juggi is what? Juggi Jopadi, what we say, right? Juggi dwellers are like the people who are living in like, kind of mud
slum
huts,
areas.
or you can say like slum dwellers. Yeah, that kind of a thing. Okay, yeah, go ahead.
In 1985, a five-judge bench of the Supreme Court established in Olga Tellis that the right to life
Olga
under
Tellis is a
Article
case. Okay, so when they say established in Olga Tellis, what does it mean? Established in the Olga Tellis case. So you have to understand this thing. So like if I say that basic structure was upheld in Keshavananda Bharti, Keshavananda Bharti is a person. Inside him, basic structure was not upheld. It was in that case which was upheld. Okay, so we generally as lawyers refer to cases just by name. You're expected to know what I'm referring to. Let's say like uh, tort. The tort law of tort was actually laid down for first time, or the duty to care was laid down for first time in dash. So what is that dash? Do you know? It had something to do with a snail in a beer. Do you know this case? It is Donahue versus Stevenson. Okay, it is the first case of tort law. So if I say that duty to care was established in Donahue versus Stevenson, or in Donahue, that's also enough. Okay, so that's how we talk about cases. So it's saying here that the five-judge bench of Supreme Court established in the Olga Tellis case. What did it establish? Mimansha, please tell us.
That the right to life under Article 21 of the Indian Constitution includes the right to livelihood and housing. It recognized two sets of entitlements as part of the right to housing, a right to notice and hearing prior to evictions, and access to rehabilitation under existing schemes for the same. These entitlements continue to be the law of the land. As is well established, the decisions of a higher bench strength of the Supreme Court are binding on benches with the same or lower bench strength. A three-judge bench of the Supreme Court is bound by Olga Tellis, and any failure to abide by that decision is contrary to the law. The Supreme Court's dissent order makes no mention of the right to livelihood and housing of those it ordered to be removed. It makes no mention of the need to provide notice and hearing, as well as rehabilitation in accordance with existing schemes to those ordered to be removed. It makes no note of Olga Tellis at all. To that extent, the order is contrary to law. This order was passed in bill originally filed in
PIL.
1984 to 85 by PIL. PIL originally filed in 1984 to 85 by environmentalist MC Mehta in what is popularly known as the Delhi vehicular pollution case. It is not clear why the Supreme Court has continued to keep the case alive while moving beyond the original subject of the petition. The multiple lives of this PIL have certainly been devastating for Delhi's Jhuggi Jhopri dwellers. So can you scroll down?
Yeah.
The Supreme Court has previously held that persons who are vitally affected by any decision of courts in exercise of their jurisdiction must be heard by the court. Moreover, Article 226(3) of the Indian Constitution is explicit about the need for parties to be heard before an interim order is made against them by high courts. It is unclear why this basic principle of natural justice has been abandoned by the Supreme Court in cases such as this one.
Okay, good. Now, PIL is public interest litigation. Okay, so anything which relates to something which will actually be in benefit of the public at large, that is called PIL. Like, for example, if you talk about right to clean air, if you say like nowadays the AQI or the air quality index of the country is very, very bad, especially places like Delhi. Okay, which is competing for the worst air quality in whole world also. Okay, so now if somebody files a case in the Supreme Court saying that there should be an order that no car can run which doesn't meet all the pollution requirement or this or that or whatever it is, that is called a PIL because it is in public interest. Nobody is gaining anything from that apart from the public, right? If I file a case against you, that means I'm gaining something if I win. But if I file a PL, I'm not winning anything exactly. But the whole country is getting clean air. If I file a PIL regarding clean air and I win that PIL, right? So PIL is filed for public good, not for personal good. Okay. Now, MC Mehta is a person who used to file a lot of PIL. He is known for filing PIL. Okay. So he has filed a lot of PIL and won a lot of cases. Okay. Out of which one was this also, where he was talking about right of the Jhuggi Jhopri dwellers or the slum dwellers. Okay, fine. Now, Memansha, can you explain a little bit about this passage, what it's actually trying to say?
This passage is talking about a case of Olga Tellis in which there is an incident about the house in which he was living, like the person was living, and then he was made to abandon that house, and then like it's talking about article it also talking about the article 21 of the Indian Constitution, and about also about MC Mehta, like he used to work for like do PIL and all, and like how he helped this person and all.
Okay. And why the author is saying that it's a problem for the Juggi Jopri dwellers? What's the problem?
Like they are not aware of this article, that's why.
Okay. And is there any other problem with Supreme Court and this and that?
The Supreme Court is not abiding by its order. Like in recent order,
Its own
the
order.
passage itself talks about that they have not, while passing the order, they didn't consider rehabilitation and providing right to hear to these Juggi dwellers, right to hearing.
Right. Right. They were supposed to be given a right to notice, like at least inform me, no, if you're going to evict me. Okay, this was not given. And also the previous case of Olga Teles, which was a higher bench of a five-judge bench, was not abided by a smaller bench of three judges. Okay, so that is very, very strange. That is not normal, right? So this is what has been the problem, according to the author over here. Okay, now. I hope it's clear to everybody. It's very simple. It's nothing complicated. Let's move to the questions. Question number 6, Ashank, please answer.
So I think the answer will be one and two both. B.
What about right to privacy?
So because in the passage of Olga Terrace, it talks about only two things, include a livelihood and housing, not the privacy.
Right, right. It is nowhere talking about
Right to privacy.
privacy. Right. Although that might be a
No, sir.
reason
In
also.
housing, they are talking about notice and hearing, but they didn't talking about privacy.
Yeah. Means that might be a issue, but if it's not mentioned in the passage, then how can we just assume?
Yes,
Right.
sir.
That it's a issue. Okay. Good. Now, next question, John.
The right to housing involves the following entitlements as per Olga List: 1. The right to notice and hearing. 2. The right to cities. 3. Right to rehabilitation. I think the answer would be option D, right to notice and hearing and right to rehabilitation.
Good. Okay, the option is, did you say D or B?
I said D, sir. D for Delhi.
Yes, D for Delhi. You are absolutely correct. It is both right to notice and hearing, right to abide, and right to cities is nothing. I mean, it's pretty obvious that this is the correct answer. Okay, good. Now, next, uh, question number 8. I will ask Mimansha. Go ahead.
So for this question, I'm confused between C and D.
Okay, and why don't you read out the question first? Then we will discuss what is the correct answer.
The question says, in the case of Keshwananda Bharti versus State of Kerala, a 13-judge bench of the Supreme Court held that the Parliament can only amend the Indian Constitution subject to the basic structure. Now, in 2020, the Supreme Court, in a five in a five-judge bench decision in Harry Potter versus Jon Snow, held that the Parliament has the unlimited power to amend the Indian Constitution. Will the decision of the Supreme Court be valid?
Okay, now, if you see the three options out of four, they all talk about whether a smaller judge bench can overrule a higher judge bench, so something like this. D talks about something totally different altogether. Usually, when three options out of four are talking about one thing, then the answer would be within those three things only, rather than the fourth one. Most probably. Sometimes in 10% of the cases it's different, but like if I'm talking about, like, if I say like what's your favorite color, and then I say blue, yellow, black, and then I say flowers, generally it means that the answer would be in between blue, yellow, black. It would not be something totally unrelated to the other three options. Okay, so here, um, that is one way to go about. And logically speaking, you can also see it like, will the decision of Supreme Court be valid? Basic stuff is not mentioned in the, it was, this is seems a little off topic to me personally. It doesn't seem very relevant to me. Like, it seems like he just something they have written over there, which doesn't make a lot of sense. Okay, I would rather focus on the other three uh, options. Now, uh, as a later bench cannot overrule the decision of an older bench, this, that, little bit you need to know, and little bit you need to read from passage also. Okay, now in passage, if you see, here it is saying, as is well established, decision of a higher bench are binding on the thing. It's very, very clearly written. Isn't it clearly written? Huh?
Yes, sir.
It's clearly written. So now what will be the answer? Have you read this? Read it out loud once. What's written over here?
As is well established, decisions of a higher bench strength of the Supreme Court are binding on benches with the same or lower bench strength. So
So that
option
means what will
C.
be the answer? Option?
Option C.
Very good. It is option
C.
C.
Yeah.
Okay, very good. Fine. Next. Priyanshu.
Mr. S.K. Guha owns a leather factory in Agra. The residents of Agra has filed a writ petition before the Allahabad High Court to close down the factory as it infringes their right to a clean environment. Without hearing the contentions of Mr. Guha, the High Court has offered the government to shut down the factory. Based on the above excerpt, which argument do you think will be sound in a challenge against this decision? Option A, the High Court's decision is wrong as writ petitions cannot be filed against private citizens. I think it's a wrong option because the passage itself is silent about this, about writ petitions, whether they can be
Hmm.
filed against private citizens or not.
Hmm.
Option B, the High Court's decision is wrong as Mr. Guha was not allowed an opportunity to be heard. Okay. Option C, the High Court's decision is wrong as right to clean environment is not recognized by the Indian Constitution. Again, the passage is silent about this. Option D, none of the above. Option B would be the right answer.
Option B, Bombay would be right answer. It's very, very clearly written
Yeah.
in the passage. Okay. And if you talk about right to be heard, okay, what do we call it in Latin? There's a maxim for it. Do you all know? It is called
Audio
audi
alteration.
alteram partem. Audi alteram partem means hear the other side. Okay, so if I'm saying something that he has done this to me and that, will you directly go and punish that person? No. First, you will hear their side of the story also, right? Similarly, over here, Mr. Guha should also have been given an opportunity to be heard before it was decided that what is to be done in that situation, right? That is only natural. That is only fair. Okay, that's right. The answer. Now, PIL is used to do. I just told you what it is. What is the answer?
Option A.
A.
Option A, public interest litigation. Very, very simple. Something in public interest, a case that's filed, public interest litigation. Very, very simple. Now, can you all think of any public interest litigation? Who can think of a public interest litigation and tell me? Like I told you, I would file a PIL for clean air. I would say that the air in the country is very, very dirty, and the government should be directed to put up huge air purifiers in each part of the country, just like Gautam Gambhir has done in his locality, in his constituency. Right. Similarly, there should be giant air purifiers everywhere. I have requested the court, please order the government to do that. That's a PIL. So can you think of any PIL?
Yes,
Tell
sir.
me.
This year in 2022, 2020, PIL was filed to postpone the CLAT examination.
Can you think of a PIL that you would like to file?
Oh, either you would like to file. Okay.
What would you file a PIL for if you had to file? Think about it. You all are going to be lawyers. What sort of
Yes,
PIL would you file?
there are a lot of illegal constructions on roads in my town.
Yeah.
So like
Very good.
people have
Very, very good.
constructed on
Yeah.
the road like the land which is supposed to be footpath.
Yeah.
So they're like
Very good. Very
so
good. That could be a that could be a PIL because that is obstructing the traffic which is going on over there, right? I might file a PIL for clean water. The water in the country is very, very dirty. The Yamuna and the Ganga are being polluted. So I would file a PIL saying that they should not be allowed to put the effluents and the factory waste into the river. That is a PIL, right? So these kind of things. All right. Whenever you come across topics like this, think for yourself, like what you would like to do in that situation. Okay. That will help you a lot. Okay. Next. Third passage. Um, who all have not read so far? I think Varishta, have you read?
No, sir.
Please go ahead.
Passage 3 Legislative Corpus and the 10th Schedule Mahalakshmi Pavani the leaflet. The
10th
Rajiv
schedule of Indian Constitution. Sorry, sir.
The Rajiv Gandhi led government was successful in passing the constitutional 52nd Amendment Act 1985 in Parliament that saw the addition of the 10th schedule to the constitution, commonly referred to as the anti-defection law. This legislation was seen as an instrument to control and curb the evil practice of defection and uphold the sanctity of the legislature. The 10th schedule applies to both houses of the parliament as well as the state legislature. The 10th schedule prescribes two conditions that would attract disqualification for a member. A. If a member voluntarily gives up membership of the political party from which such member has been elected, or B. If a member votes or abstains from voting in a manner that contradicts the direction issued by the political party to which he belongs. However, paragraph 4 of the 10th schedule states that a member shall not be disqualified if he belongs to a faction that comprises at least two-thirds of the members of the original legislative party. This faction may have either merged with another political party, formed a new political party, or opted to function as a separate group. The Speaker or the Chairman of the House is the sole adjudicating authority with respect to matters under the 10th schedule and whose decision shall be final. Although paragraph 7 imposes a bar on the jurisdiction of courts in Quixote, Holohan versus Zachilhu and others, the Supreme Court said that the office of the Speaker is quasi-judicial authority whose decisions are amenable to judicial review. Thus, the 10th schedule does not oust the jurisdiction of the courts under Article 136, 226, and 227 of the Constitution. It is also incumbent upon the Speaker of the House to follow the principles of natural justice while adjudicating proceedings under the 10th schedule. Earlier this year, another three judges bench of the Honorable Supreme Court in Kesham Meghchandra Singh versus Honorable Speaker, Manipur Legislative Assembly and others called upon Parliament to consider establishing an independent tribunal to impartially adjudicate upon disputes upon the 10th schedule. The tribunal must be headed either a retired judge of the Supreme Court or retired Chief Justice of a High Court. The court observed the possibility of natural perceived bias by the Speaker given the fact that the Speaker would typically be chosen from the ruling party. This view was similarly echoed by Justice J. S. Verma in his minority opinion in Quixote Holohan. Sir, can you scroll down?
That's about it. That's it.
Okay,
Okay.
sir.
Now tell me, what is this Quixote Holohon?
I don't know, sir.
Okay. So what do you
So
think
I
is this
think that that's the
Quixote Holohon? What we just discussed right now, that minority opinion in Quixote Holohon. What does it mean? What is this Quixote Holohon? Basically, it is a case. Didn't I
Yes,
just
sir.
tell you? We talk like this, like this in Keshan on the Bharti, it was this. Right. It's mentioned here also. Quixote Holonon, first they told you the whole case name. And then you talk like this. In Quixote, it was held like this. Okay. So remember that. That's how you see, when you are becoming a lawyer, you should know how lawyers talk. Lawyers talk like this. Okay. So if I say it was the same thing in Keshavananda, that this happened, it means it's a case. Okay. Now, what view was echoed in Quixote? Huh?
So that means there may be biased decision taken by the speaker as he would be of the ruling party. I
Why
mean, of
he?
that
Why not
state.
she?
Okay, he or she, whoever will be the speaker.
Have you heard of any female speaker?
Yes, sir. Sumitra Mahajan.
And Meera Kumar also.
Yeah, Meera Kumar also.
Good. Okay. Now,
Yes, sir.
what is this passage trying to say, Varishta? Tell me.
So it basically is telling us about the 10th schedule that was put up and about the, I mean, like disqualification for a member of the parliament. I mean, and the
Yes.
different, I mean, different rules that he should abide by, like if he gives up the membership of the political party, or I mean, if he doesn't vote in the matter in which he is told to, and such, and the
Okay.
jurisdiction of courts under Article 136, 226, and 227 of the Constitution too, and upon the rights of the Speaker of the House to take the decision.
Correct. Okay. And tell me what was the discussion and what was held in Kyoto?
Uh, that the office of Speaker is a quasi-judicial authority whose decisions, I mean, they may be reviewed by the judges or
Very
I mean the
good.
court.
Yes, very good. So suppose in parliament that I am the speaker, in parliament I took one decision, it doesn't mean it's final. Okay, it
Yes,
means
sir.
that the judge can actually look at that decision also and say whether it was a right decision or wrong decision.
Or a wrong
Because
one. Yes, sir.
maybe that the maybe there was a discussion that okay, party A and party B are there, and there is a matter which is like in dispute between the two, and I said that party B is correct, and it turned out that I was formerly a president of that party. Obviously, I will vote for party B or I will support party B. So at that point of time, a judge will review and say, was the decision given because party B actually was good and correct, or was it given simply because I was the president of party B, so I will favor them? Okay, that is called judicial review. Okay,
Yes, sir.
good. Now, what is 136, 223, and 227 of Constitution?
So Article 136, it's about sir,
Any
it's about
this is this is something anyone can answer. What is 136, 226, and 227? Come on.
the so special leave to appeal by the Supreme Court.
That's which one?
136.
And 226?
Sir, I don't know.
Find out. You have got a
So
phone on the
Article
phone.
226 is the power of high courts to issue writs.
Very good. What are it?
So writs, they are given in the Article 32, and they are the hard.
But you just said 226.
They are given in the Article 32 for Supreme Court, and like High Court has the same power in Article 226.
Very good. Okay. And what are these things? What are it?
So writs, so they are as stated by Dr. B.R. Ambedkar, they are the heart and soul of the Constitution. Article 32, like the heart and soul of the Constitution. And there are 5 writs: writs of habeas corpus, certiorari, mandamus, prohibition, and I guess there's another one I'm forgetting the name.
Quo warranto.
Quo
Quo
warranto.
warranto. It means with what authority?
With what?
Okay. Habeas corpus means produce the body. Means if somebody is in detention, then they can claim that it was illegal detention, and then they want to produce the body. So this was done in emergency because a lot of people were just like imprisoned, and the right of quo warranto was also taken away during emergency. And the question that came before the court was that does the right of quo warranto still exist in emergency, or you don't have the right to question why you were detained also? You can just be taken from road, put in jail, and you can't even ask why. Okay. And this was decided in the case of which case? I won't tell you the name of the case, but it is called habeas corpus case. Okay, now you have to find out the name of the case and tell me. It is called the habeas corpus case, and there was a very, very famous dissent in that case by H.R. Khanna, Justice H.R. Khanna, who said no. There must still exist the right to habeas corpus, while everybody else said no, there is no need for that. Okay, and that cost him the chief justiceship of the country because he was superseded by his juniors, because that was not a judgment which was appreciated by ruling party at that time. Okay, so that is one thing. Now, rest of the writs also very, very interesting. Okay, mandamus means a direction, do something. Quo warranto means with what authority. Prohibition, I think it is very obvious. Certiorari, all these things you must know very well. In next class, I am going to ask you. Okay, all of you must study the writs. There are 5 writs. In next class, I will ask you, and I will ask anybody. So be ready with it. Okay. Now, moving to the questions. 11. Who was the last one? Priyanshu, have you answered? I don't think Priyanshu has answered yet. Priyanshu, question number 11. Come on.
So I have answered, but option C.
Okay. Priyanshu has answered. It's option C. It's 50 seconds. Very good. It's a matter of general knowledge. And then I think I will ask Sachin. Sachin, you have not spoken till now, I think. Sachin, you do question number 12. Okay.
Yes, sir.
And you read the next passage as well. You have not answered much. Okay. Go ahead. Yeah, go ahead, Sachin.
Yes, sir. Mr. Potter is a member of ruling party Gryffindor in the state of Hogwarts, a newly formed state in India. The government has decided to bring significant amendment to reasonable restriction of underage secretary act through a bill. Since Gryffindor was confident about the passage of the bill, and since the Chief Minister, Mr. Granger, was best friend with Mr. Potter, the party did not issue a direction to its members on how to vote for the bill. The bill was passed without astounding majority. After the vote, the party was shocked to find that Mr. Potter had voted against the bill, had decided to approach the Speaker under 10th schedule to disqualify him as a member of the Assembly. As the Speaker, what will your decision? I think option A, sir.
Why?
So because he didn't give any him direction to how
And
to
where it
vote.
says that they have to give any direction?
Sir, in question, sir.
Where?
Clearly in.
Where does it say so? Tell me.
I read somewhere else, sir. Sir, in question, it's clearly said, sir, he didn't give.
I understand that is given in the question, but can you tell me where it is? First para, second para, third para, like this.
I think I read it, sir.
Okay, if you read it again, no problem. It's given over here, okay?
Yeah,
If
yes,
a
sir,
member
yes.
votes or abstains from voting in a manner that contradicts the direction given issued by the political party, that means like it's a party whip, okay, or a party line, okay, or a party mandate, okay, which says that you have to do this. But if it doesn't say anything like that, you can do whatever you feel like doing, right? Okay. Next, question number 13. Anyone can answer.
D option.
Option D.
D for Delhi.
D for Delhi.
Yes.
So basically, it applies to everyone.
Yes, sir.
Right. Okay, good. Question number 14.
2/3 B. Option B. B for ball.
B is correct.
D for
B
Delhi.
for ball.
B for ball.
B for ball. 2/3. This is a matter of general knowledge. Okay, good. Now, question number 15, I will ask Shafi. Shafi, go ahead.
Can the decision of the speaker to disqualify a member be challenged in the court? Option A.
Option A.
Wait. Sir, option B, sir, B.
Why not A?
Sir, because there is a mention of quasi judicial body.
Huh?
सर वहाँ पे दिया गया ना कि क्वासी जुडिशियल बॉडी और एमिनेबल है।
Can't hear you.
सर एम आई ऑडिबल?
Yeah.
हाँ सर, वहाँ पे लिखा हुआ है ना कि मतलब किसी भी स्पीकर को अगर देखा गया तो क्वासी जुडिशियल है, उसको एमिनेबल किया जा सकता है।
Yes.
Amend किया जा सकता है।
Yes. That's right. I'm just okay. Good.
Sir,
Fine.
excuse me, sir.
Yeah.
Sir, I have a question. I have a doubt in one question.
Yeah.
In question 14 or 13? 13, sir.
Huh.
The 10 schedule applies to, because
Yeah.
in passage it says it applies to both the house of the parliament.
प्लस स्टेट लेजिस्लेटिव आल्सो।
I hear it, sir. Very clearly it says.
Okay, yes, sir, yes, sir. Okay, as well as 10 also. Okay, sir.
Good. Okay. Question number, passage number 4. Who has not read till now? Shantanu, have you read?
No, sir.
Please go ahead. Read it out.
Passage 4. An executive emergency, India's response to COVID by Gautam Bhatia.
Hmm.
Uh, part 18 of the Indian Constitution specifically authorizes the President, acting upon the aid and advice of Council of Ministers, to declare an emergency. An emergency must ordinarily be ratified by the Parliament within a month. During the period of emergency, fundamental rights, apart from inter alia the right to life and personal liability, may be suspended. Nonetheless, the preconditions for an emergency proclamation are strict. There must exist a state of war, external aggression, or an armed rebellion. The Indian Constitution has no provision for environmental or public health emergencies, and indeed, prior better experiences with politically motivated emergencies has left successive governments wary about formally invoking emergency powers. Unsurprisingly, therefore, the central government has not chosen to go down the emergency powers route in order to tackle COVID 19. The full extent of restrictions imposed by India's lockdown, therefore, becomes clear only by weaving through a complex three level web. The central government's guidelines under the National Disaster Management Act, the several state governments' regulations under the EDA, and local officers' order under the Criminal Procedure Code. As pointed out above, with respect to central government at each level, which is common, is that the existence of broadly worded umbrella legislation is taken as a cover for what is essentially ruled by executive decree. The logical consequence of this interlocking web of executive decrees, many of which are vaguely worded, is that while the lockdown is stringent and severe, its enforcement is also arbitrary and sometimes violent. Movement is difficult without a special government issues passes. There is no specific restriction on any individual going out, whether to exercise or to buy essential commodities. But nonetheless, there are reports of police banging morning walks as well as extra legal sanctions that do not follow even upon such imagined breach of the lockdown. Vaguely and open ended characters of statutes have also led to a number of measures that infringe civil rights with dubious legal basis. The absence of firm statutory basis for such move is compounded by the fact that many years after a landmark constitution case on the right to privacy, India still does not have a data protection law. Consequently, there is no statutory standard that governs data collection, processing, and use by the state governments or by the center. There exists a constitutional standard of proportionality, a standard familiar to students of global constitutionalism that requires state actions to meet the test of legality, rationality, necessity, and strict proportionality.
Okay. Now, what did you understand from this?
So, the author is saying that he's trying to tell us that a country has invoked emergency earlier, And there is no constitution provision for provoking emergencies for environmental or public health crisis. So in the COVID pandemic, the government chose not to invoke emergency, but rather they took help of the Environment National Disaster Management Acts. And then in the second last paragraph, the author is trying to tell us that uh, the he's trying to say that he gave an example of how there has been an issue regarding the data protection law, and still there is no law regulating the violation of our privacy, and stating that the author is saying that basically there should be an open-ended law that that measures our infringement of civil rights, like the ones we have seen in the lockdown, where police are banking morning workers as irrespective of the fact if they're out to buy essential commodities or for some other work.
Yes, yes, you are right. Okay. Now, emergency is again in the news right now. Does anyone know why? You all are not reading newspapers, is it?
So because
Are
of
you all
fast.
are you all reading newspapers? Tell me very honestly. Yes or no? Huh?
Yes, sir.
Are you all? Answer me, everybody. Come on. Why you
No,
all
sir.
not answering? Yes or no?
Yes, sir.
Yes, sir.
Not
Yes.
regularly.
Not reading. I don't think you all are reading. If you were reading, then you would know what I'm asking you. Like there's something regarding the emergency which is very much in news right now. What is that?
It
No
is
one knows it.
regarding a 94-year-old woman who had moved to Supreme Court for that.
इंदिरा
For
गांधी
what? What about Indira Gandhi?
सर उस समय किसी महिला के मतलब 1974 में जो इमरजेंसी हुआ था उस समय शायद कुछ
हाँ 1974 में इमरजेंसी हुआ कोई महिला कुछ की what is the issue?
सर
What is
वो
the
कुछ
issue right now?
कंपनसेशन मांग रही थी उसका मतलब गलती नहीं था ऐसा कुछ
नहीं वो तो ठीक है बट इशू क्या हो रहा है अभी इमरजेंसी को लेके वायर भी चर्चा क्यों हो रही है इमरजेंसी का एक दो बार में चर्चा क्यों हो रही है अभी न्यूज़पेपर नहीं पढ़ते हो तुम लोग लगता है व्हाई इज इमरजेंसी न्यूज राइट नाउ come on quickly google it and tell me why is it in news right now let's see who is the first one who can answer really start reading newspaper nothing will help you my these classes which you are attending and all the worksheets you are doing and all the mock tests you are doing it's useless trust me it's useless if you don't read newspapers you are wasting your own time very honestly I'm telling you you are wasting your own time if you don't know this basic thing that why emergency is in news that means you are not reading newspapers and if you are not reading
Sir,
newspapers there's no point yes Shantanu
it is regarding a woman named Veera Salin's petition in the Supreme Court, and she's asking that the whole proclamation of emergency in 1975 to be declared wholly unconstitutional. She has filed an appeal in the Supreme Court, and it is because during the emergency, her family was hounded by the authorities and they were forced to leave India.
okay and then
And then, like, she has filed appeals for the same, but like she haven't received any compensation as such. So now she's asking for the whole this emergency thing
I
to be declared as
understand that what she's asking, but after she asked the court, then after that, what happened? If you ask me for something, then what will happen?
you can
That shouldn't have happened.
No, I mean, I'm saying if you ask me, let's say that you ask me for my pen, okay, then after that, what will happen? After you ask me, what will happen?
either you'll give me your pen or you'll not.
Exactly. Either I will give you or I will not. So after she asked the court, then what happened? You don't know.
No, sir.
Find out. Tell me. Find out. I'm waiting. Very bad. This is why I tell you, don't read compendiums. Don't go for a quick fix. Newspaper is what, 20 pages, yeah. You can't read 20 pages in a day. Yeah. And every day if you read, then you will know every day what happens. Right. If you read monthly compendium, then you won't know. Like you found out that she approached the court, but after she approached the court, after that what happened? Let's see who can tell me. Very sad. You all should be better prepared. I expect more from you all, you know. It's taking you so long. It should not take you so long also. Come on, quickly. It's been 1 minute already, and you all still have not answered. Not able to find it also on Google.
Sir, issued notice to central government.
Who issued?
Bench of Justice, Supreme Court.
Yeah, good. Please, there's a lot of disturbance. Shafi, there's a lot of disturbance in your mic. Please try to get a better audio next time, okay? Because when you're answering, we can't really hear you properly. Yes, after the court was moved, then the court agreed that okay, we will look into it. Okay, and they asked the government that okay, fine, why don't you do something? You all should know all these things. It's very, very basic. I don't even like kind of ask you to read in detail. I just ask you at least read the newspaper in brief, so you will have some sort of idea. Like you are writing flat and you all are clueless. Shameful. Shame on you all, really. I'm not trying to insult you or just berate you or shame you, but this is something so basic that I'm surprised that you all don't know. And very honestly, if you all don't have this basic level of knowledge, then you might as well stop preparing for CLAT right away. Don't waste your time because 5 months down the line you will fail. Better you leave it right now. Hmm. Otherwise, you will think, oh, I did so much effort for 5 months, 6 months, and there was no result. Trust me, you will not do well if you don't even know this simple thing that what has happened in the emergency right now. Okay. Not to insult, trust me, I'm not trying to insult you or anything like that. I'm just telling you very honestly that this is something very simple expected from you. It's like if I ask you that which alphabet comes after A, B, C, D, and you say, I don't know. Like, what will you think about such a person? Right? That's how I feel about you right now. But you still have a chance to show me that you are worth something. Okay. So please do it quickly because you don't have much time. And if this is your level right now, you have a lot to do. Trust me, you have a long way to go. Okay. Now, um, question number 16. I mean, see, I'll tell you very honestly, I'm not the type of person who will like pat you on the back and praise you and kind of like encourage you when you are going in the wrong direction. Okay. I will always try to put you onto the right direction. And right now, you are on a very, very wrong direction as far as your GK is concerned. So please read the paper with some level of seriousness. Okay. Because it's not in a good condition right now. Okay. Let me just say it that much. I don't like to talk much about these things, but it's my duty. Okay. Now, question number 16. Um, this time I will allow you all to raise your hand. Okay, for a change, for this passage, you all raise your hands. So whoever wants to answer, yes, Shafi, go ahead.
Sir, option first.
Option first means option A.
Yeah, sir. Yeah.
Are you sure? Yes, Varishtha.
Sir, option D, none of the above.
It nowhere says that both president and governor are allowed. Only president is allowed. Okay. 17. Mimansha.
Sir, option B. It's written in the first para.
Very, very clearly it has been written.
Yes, sir.
Okay. Although when the emergency was declared in India, there was no war or armed rebellion, external aggression. Okay. So somehow or the other, internal disturbance was the ground. Now, how was it? Nobody knows. So in next class, you have to find out. What is the first homework? Do you remember?
So
What's
I
the
think
first
it
homework I've given you?
came after an amendment that internal disturbance was removed and armed rebellion was included.
Okay, very good. Now you tell me where, which amendment and how. Okay, in the next class. Fine. And what is your other homework? Do you remember?
No, 5 all
Fill out
reads.
the 5 legs. Yeah.
Good. At least you all are paying attention to the homework. Okay. And you have to remind me. In next class, I will ask that what is the homework? You have to tell me, sir, this is the homework and I have done the homework and this is the answer. Okay. So first is about writs. Second is about emergency. That if internal disturbance is not a ground, then how was the emergency declared in 1974? Right? Okay. 18. And I think Shantanu has already given the answer, but I want a more clear answer. Okay. 18. Google it. Come on, quickly.
Sir, C. Epidemic Disease Act.
Simple. 19.
Sir, A.
Option A.
Where is it given in the passage?
Second para, first line.
Huh?
It's given in the second para, first line. The Indian Constitution has no provision for environmental or public health emergencies.
Very, very simple. Good. Okay. Next. Quickly, come on.
Option A.
Why do you say option A?
So because it is mentioned in the passage that the
Where?
basic structure cannot be amended.
Sir, first
We are not
paragraph.
talking about.
Right to life, the first paragraph, third line.
Okay. And it is obvious, isn't it? Right to life is the most basic right that any human being has. And whatever you do, you cannot take away the right to life, isn't it? That's the obvious thing. So you can take away their right to freedom. Like, for example, habeas corpus, writ has been a kind of suspended. It means that you can pick up someone from the road and put them in jail. That means you have taken away the right to freedom, Article 19. But you cannot take away Article 21. That is right to life. Okay. Very, very important. Now, okay. Let's try and do one more passage. All right. Before we close for the day. And that is passage number 5, which will be read out by John. John, have you read a passage yet?
No, sir.
Okay, go ahead.
Passage 5. Arbitrariness as a test of Article 14 violation. It is both logical and intuitive to start with the text of Article 14. The state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. The earliest decisions of the court has had a fairly consistent view of Article 14. The first part of the article, which speaks of equality, is commonly accepted to be a guarantee that no person is above the law. This guarantee is made effective by its corollary that the second part, which offers to persons the equal protection of the laws. How are these interconnected guarantees made effective? To quote from the minority opinion of Shastri J. from State of West Bengal versus Anwar Ali Sarkar, the second part, which is the corollary of the first, and is based on the last clause of the first section of the 14th Amendment of the American Constitution, enjoins that equal. Sir, could you scroll down?
Yeah.
Um, enjoins that equal protection shall be secured to all such persons in the enjoyment of their rights and liberties without discrimination or favoritism. Or, as an American judge put it, it's a pledge of the protection of equal laws. That is, laws that operate alike on all persons under like circumstances. And as the prohibition under the article is directed against the state, which is defined in Article 12 as including not only the legislatures but also the governments in the country. Article 14 secures all persons within the territories of India against arbitrary laws as well as arbitrary application of laws. This is further made clear by defining law in Article 13, which renders void any law which takes away or abridges the rights conferred by Part 3, as including, among other things, any order or notification, so that even executive orders or notifications must not infringe Article 14. This trilogy of articles thus ensures non-discrimination in state action, both in legislative and the administrative spheres in Democratic Republic of India. Contrary to the belief that arbitrariness was discovered in the 70s, it is clear from the above paragraph from 1952 that Article 14 has from the very outset been interpreted as a guarantee against arbitrary action.
Okay, very, very clear, I think. Now, please explain what this passage is talking about.
This passage is talking about Article 14 of the Constitution, which guarantees the right to equality, and it talks about how the right guarantees equal rights to persons in like circumstances. It talks about how um, it offers people equal protection in face of law, and how every law in the territory of India has equal effect on people of India on in the like circumstances.
Okay, good. Likes are treated alike and unlikes are treated unlike. Okay, so if there is a group of people, like suppose let's say teachers, okay, and I say that English teacher will maybe some kind of a thing I say that this particular teacher would be given more value or more weightage or more something like that, which others will not get. Okay, that is discriminatory, isn't it? Because all teachers are alike, all teachers are the same, all teachers deserve the same amount of respect and loyalty and whatever it is. Okay, but if I say that teachers will get more respect than student, is that discrimination?
No, sir.
Why? Because
it compares teachers with students which are not like circumstances.
Because a teacher is not equal to student, right? There's some difference
Yes,
between
sir.
teacher and student, but there is no difference between teachers. All teachers are same. All teachers are worthy of same amount of respect. Okay, but of course a teacher will get more respect than a student, isn't it? Suppose there are judges and lawyers.
So you are not audible.
Am I audible now?
Yes, sir.
Yeah. So suppose I say that some judges will get some kind of privileges, but other judges will not get. Okay, that is discrimination, because judges are all equal. Okay, we say like we in fact even say chief justice. You cannot give some special privilege to chief justice which is not given to others, because even chief justice is called the first among equals, so they are all equal. Understood? But if you say a judge will get some kind of a privilege which a lawyer will not get, that is fine, because judges and lawyers are not equal, isn't it? So it's the same thing when you talk about Article 14. It says that likes will be treated alike, unlikes will be treated unlike. Very, very simple, obviously. Okay. Now, let's move to the questions. 21. Again, whoever wants to answer, raise your hand. I will pick somebody. Yes, Shantanu.
So answer option D should be correct.
Why?
So because the question is asking based on the passage above, when can a law justifiably be excluded from the following of a principle of equality in Article 21? So, where, so like that's why option D.
Yeah, like I said, if there is a law which treats lawyers and judges differently, that is fine because it is treating unlike people in an unlike manner. No problem. Yeah. Okay. Next. Test of arbitrariness applies on whom? First of all, what is arbitrariness? Can anyone tell me? Yes, Varishtha. What is arbitrariness? What does it mean?
Sir, I wanted to give the answer. I don't know the meaning of the word.
How can you give the answer without knowing the meaning of the word?
Sir, I mean, I thought that would be the answer.
Okay, what's the answer?
Sir, it's option C, both A and B.
And where is it given in the passage?
So it was given not only legislative, but the government should also be included in it.
Good. But you should know what the word means. Now, please Google what is arbitrariness and tell me.
Yes. So it's private dispute resolution procedure.
No. That is
The
arbitration.
based on random choice instead of any reason or system.
If I say that from today, class will take place whenever I feel like. Okay, there will be no system to it. So maybe tomorrow I will say around suddenly around 5 o'clock I'll say okay, everybody come, we are going to have class. Then day after tomorrow I will say at 3:30 p.m. okay, now we will have class. That is arbitrary. That means that it is totally on my whim and fancy, whatever I feel like I'm doing. There's no law and order to it. Okay. So if the legislature is doing something like that, if the government is doing something, and if executive is doing something, it doesn't matter. Both are subject to judicial review. Okay. And the test of arbitrariness will apply on both. Ki, was this arbitrary or was this not arbitrary? Okay. You understand? And Varishta, what you were talking, that is called arbitration. That is something different. Okay.
Okay, sir.
Arbitration is like an alternative dispute resolution mechanism as compared to court. Suppose, like, you know, that we both are having a fight. Okay. And I know we will never fight, but suppose we are having a fight. Okay. And
Yes.
we don't want to go to court because court is very lengthy procedure and that tariq pe tariq and all those things will happen. So we both agree that listen, we are both friends with Mimansha. Okay, Mimansha is your friend also, Mimansha is my friend also. So I know that she's very, very impartial and a just kind of person. Okay, so we will appoint her as the arbitrator and we will say, like, whatever she decides, that will be the final answer. Okay, so that is called arbitration.
Yes, sir.
Now, 23.
So it should be A, equal and arbitrary.
Why?
So equal because it is applying to everyone,
Of course, it's equal.
and it is arbitrary because like the parliament is enacting it.
Yeah, because there was no consideration that 15 years, you know, like just out of nowhere, you have fixed that age. What is the age of consent in India?
18.
Huh?
16.
18.
I guess
18, sir.
16.
Are you sure? 18, 16, 18, 16,
16.
16. Where does it say so?
Sir,
I read it
in
somewhere.
Contract Act, I read about it. Minor Act.
Okay. Next homework. Find out age of consent.
It's
Someone is saying
18.
16, someone is saying 18. Huh?
It's 18.
Both of you are correct in some way. Now you find out why you said 16 and why you said 18. Both are they're not correct answers. I'm saying like both are somewhat correct. I mean, both of you have some reason for saying 16 and 18. There is some reason why you are saying 16. There's some reason why you are saying 18. You find out and tell me. Okay. 24.
Option C,
Why?
because it's written in the passage.
What is written? Where
Uh,
is it?
it's written Article 12 as including not only the legislatures but also the governments in the country.
Okay. And here it is saying that he sued his employer is government, so therefore it is valid. Okay, he can sue. Fine, good. And last question for today: will Naveen succeed in his claim? He can sue, yes, but will he succeed or not?
I think it's A.
Yes, sir. A.
You feel the order is arbitrary and unreasonable. See, it is
Yes, sir.
arbitrary because suddenly they made why two, why not three, why not one? Okay. And unreasonable, obviously, because, like, if you just, I mean, you can't make such a rule that suddenly, if I want to have more than two children, oh, there will be some kind of restrictions. Of course, some of these kind of rules are there in some countries, like, the one child policy in China, which was there. Have you heard about that? No.
Yes,
Yes,
sir.
sir.
Yes or no? Yes. Okay. So basically, they said you can only have one child because the population of China was increasing day by day, and as a result, if you had more than one child, you would not get tax benefits. Lot of problems would be created. Like they will not kill the child, the second child, but basically they will make your life hell. Okay. And I actually have some friends who are product of the one child policy, and it was a very miserable time because like a lot of children, they enjoy having siblings, they enjoy having friends, they enjoy all these kind of facilities which was not there. So some and Chinese people, like even more than Indians, the parents put pressure on the Chinese people. Okay, so the all the pressure and expectations of the parents came on that particular one child. And most of these children, they have got like severe kind of trauma and mental issues because of all the pressure that has been placed on them by their parents, right? And also now there is a very very major problem in China because there are no young people. Like if you see India, majority of the country is comprised of people who are below 35 years of age. So it's a very very young country and a very very dynamic country because we are the future, isn't it? We are the future because young people will like shape the future of the country. But in China, the population is an aging population. So when you have older people, you need to have more healthcare, you need to have more facilities, you need to have younger people to take care of them. But there are very few younger people because of the one child policy. So that is why actually it has backfired for them and it is creating a huge problem for them, this one child policy. Okay. So this kind of a order which would be passed by the government, or sorry, this the government company, would be totally arbitrary and unreasonable as well. Okay. So now we will stop here for today. Did you all enjoy the class? Did you all understand what we are discussing today?
Yes, sir.
Yes, sir.
Yes,
Yeah.
sir.
You sure? Or just because I am asking you, so you are saying yes? Was it useful for you? Maybe you enjoyed it because, like, you found it entertaining or whatever, but did it give you any sort of like, uh, benefit when it came to your studies? Did you understand what you're talking about and how to read passages, how to get the exact information out of it, how to solve the questions, all of these things? Was it clear to you?
Yes,
Yes,
sir.
sir.
Yeah? You sure?
Sir,
Yes, sir.
Sir.
sir,
Because Yeah.
The passages, the questions that we have in the 7 mocks that you've uploaded, they're the same as these sectional tests.
No, I don't think so.
Yes, sir. I've come across like I was solving this mock. The one I did yesterday, I gave, I guess it was mock 5, and the questions were similar to one of the sectional tests that I've given earlier.
Okay, you messaged me separately, but I don't. I think maybe it was one or two questions, but I think like these are very, very different questions from that set. I don't think the questions would be like absolutely reproduced, would it be?
Yes, sir. They were
No, I mean to say that maybe one question was exactly replicated there, but is it that the entire passage
the
after passage?
entire passage. It's yes, the entire
No,
passage.
I understand. I'm saying one passage with one set of questions might be there, but is it like the entire worksheet of like 8 passages is there in that mock like that? You get what I'm saying?
Not the entire worksheet. So like it was like I searched it up.
Like how many passages out of 8?
All were there. So it was like out of 8 passages, 4 were from one worksheet and 4 were from the other one.
Oh, I see. Okay, okay. In that case, I will look into it. Thanks for pointing it out. This is a bit surprising for me. Maybe like there was some inadvertent issue because this was not supposed to be the case. Maybe it was repeated instead of one worksheet was taken somewhere else. Well, that doesn't matter. I'll take care of that. Whatever it is, you all do this right now, and we will produce and give you more material in future. That's not an issue. Okay.
Okay.
Now one more thing I wanted to tell you is that like work hard. Like I said it earlier also while teaching you all, if you see an article or if you see a section which is written down over there, if you see a case which is written down over there, if you see some current event which is written down over there, do some research. You're not doing anything else, and if you are, you're not supposed to be doing anything else apart from this. Your portion has been greatly reduced from what it used to be earlier in CLAT. If you have given the other exams or you're prepared for IELTS and all, you must have seen there was legal maxim, there was like tort, contract, different kind of topics. In logical reasoning, there was such a vast syllabus. Mathematics, a very vast syllabus. General knowledge, there was static GK. You had to read about Harappa civilization, British, and this and that. It was huge. Okay. Now it's comprehension based, but you need to practice that at least, right? When you see any kind of case, you see any kind of section, any kind of like detail mentioned over there, you need to make that effort by yourself now, right? Teachers can only do so much, coaching can only do so much, telegram groups can only help you so much. Ultimately you have to help yourself. Okay, so please make that effort. Be a little more up to date with the news, be a little more up to date with like the cases and the legal current affairs which are happening around you. They are very, very relevant. Okay, so yeah, you all are doing well. I feel that you all are very sincere students. Okay, and you all are making that effort, but you all need to push yourself a little harder, because the one who pushes a little harder than the others, that's the one who will win. Everyone is working hard, everyone is pushing themselves, but the one who pushes little bit harder, that's the one who wins. Okay, and don't lose focus, don't lose heart, don't lose faith. If you are kind of going wrong, or if you feel like you are not achieving what you wanted to, or you are like not understanding what's going on, the solution is not to cry, the solution is not to be depressed, the solution is not to give up, solution is to work even harder, right? So keep at it. I'm here with you, all the other teachers are with you, and everyone wants you to succeed, right? If you do well, everyone will be happy. If you do badly, everyone will feel sad. Okay, so do it for yourself and do it for everyone else. There's really no problem, there's really no big deal to it. Just keep working hard. 6 months down the line, I'm sure that things will be great for you. Okay, so with that, let's close the class for today and see you all next week. Okay, thank you
Thank
so
you,
much.
thank
Have
you,
a great
sir.
evening, rest of the evening
Thank
ahead,
you,
and
sir.
have a great week ahead, and see you all again next week. Okay, take care, bye bye, all the best.
Thank you, sir.
Thank you.